My name is Catherine Willis. Today we will be discussing divorce-related legal processes and ethical considerations regarding the role of MFTs in these processes. It is important to understand that divorce laws vary by state. In general, the divorce process will include some sort of separation of the couple due to discourse in their marriage. Every state has their own unique paperwork which must be filed with the court, and each state has their own governing body. I currently live in the state of Hawaii, and the governing body for divorces here is family court. Each state also has its own list of fees that go along with the different items being filed, such as declarations of separation, petitions for divorce, custody agreements, child support, and so forth. Most states do not require you to have legal representation, although it is always advised, and most states offer some sort of options for low-income families or victims of family violence who cannot necessarily afford all of the fees that come along with hiring attorneys. Mediation might be part of the divorce process if the couple is not already in agreement as to how the assets will be divided or custody and visitation plans. While some states do not require the couple to show up in court in person if they are already in agreement to the divorce terms, there may be a formal hearing to hash out some of the items not already agreed upon. Custody battles are common hearings in all of the states when it comes to the general divorce process. Sometimes the hearing will bring about additional tasks that must be completed before the divorce can be finalized. This might be revisiting the parenting plan or following up on custody evaluations. Once all of the court orders have been fulfilled and filed with the court appropriately, the judge can sign the divorce documents, they can be filed with the court, and the divorce will be final. Most states are currently in agreement for general items such as acknowledging family violence as grounds for divorce, but other details, however, depend on the state in which you reside. Let's look at some of the different requirements for each state regarding the general divorce process. Here, all of the green states require couples to be legally separated for a period of time before being granted a divorce. Being legally separated often requires declaration of separation being filed with the court, but can also involve separation without filing with the court, so long as the court is confident at the time of divorce filing that the potential for reuniting is not probable and that granting the divorce will not bring about ill consequences for the community or for those involved. Specific guidelines on this vary by state. I currently live in Hawaii, and the guideline for separation is 2 years prior to divorce being granted. Here you see all of the states in green allow both at-fault and no-fault options for divorce. The blue states offer only no-fault options for divorce, meaning that divorce can be granted without requiring at least one individual to take responsibility for the deterioration of the marriage. And here we see that most states have a minimum time period that at least one individual in the couple must reside in the state prior to filing divorce. The only states without a minimum residential requirement include Alaska, Washington State, Wyoming, South Dakota, Iowa, and Louisiana. Here in Hawaii, the residential requirement is at least 6 months. Custody battles are a common area for MFTs to become involved in divorce proceedings. This is because many factors come into play when it comes to determining child custody and visitation, and therapists theoretically have access to a lot of this information and can provide recommendations based on their understanding of how different determinants will affect outcomes for children. In a while, we will discuss ethical considerations for MFTs involved in litigation for clients. This is because there are some specific guidelines set forth by the AAMFT that regulate our involvement, which we'll discuss in further slides. But for now, let's look at the different ways in which MFTs can be part of child custody. Therapists may already be working with a family who then decides to pursue divorce. In such cases, that therapist will avoid conducting any of the evaluations for determining child custody in order to eliminate potential conflicts of interest as per the Code of Ethics. That therapist can, however, provide feedback to the guardian ad litems and other court participants weighing in on the decision-making processes per the client's formal release of information consent. In these cases, The therapist may also need to consider conflicts of interest in continuing to work with the different members of the family and may need to initiate transparent conversations with the family about the potential conflicts and mitigation strategies, such as referrals to different clinicians or different resources. This could be especially relevant if the divorce becomes tumultuous. Another way MFTs might be involved in divorce proceedings is if they are hired specifically for the task of evaluating custody agreements and caregiver mental health. In these cases, the therapist will not have already been working with the family prior to the litigation process, but instead would be hired after the initiation of the process for these specific tasks. Oftentimes, legal aid centers and family court centers will have registries or resource lists of qualified professionals in the area who provide such services, and the family can hire those therapists or social workers accordingly. A third way the MFTs might work with a family through a divorce process would be through an outreach or community education program. I currently live on Oahu, and this island has a program called Kids First. The goal of this program is to help families with children work through the tough process of separation and divorce. It is meant as a support and education program which involves role-playing, informational seminars, opportunities for family members to ask questions and have their worries, thoughts, and hopes for the process validated by qualified therapists and social workers who facilitate the program. If there is a child between the age of 6 and 18 years old in the family pursuing divorce on Oahu, this program is actually a legal requirement before divorce can be finalized. There are many ethical considerations to be made when working with a family through separation and divorce, especially when participating in any sort of litigation or when providing recommendations that will affect decision-making for the family. We need to be cognizant of the boundaries of maintaining ethical work. Respecting diversity includes maintaining our cultural competence, understanding the unique characteristics of the family and their values and their beliefs that make up their daily life, and honoring the fact that what works for one family may not work for another, and vice versa. Especially when making recommendations for custody and other strong decision-making points, combating bias through competence and openness to the diverse ways of life will be key. Consent, disclosure, and confidentiality play a huge role in litigation issues because they all have to do with information being shared. In a bit, we'll be discussing subpoenas, but the fact of the matter is we need to maintain transparency with our clients about our credentials, the weight they hold in information and recommendations being shared in court and with members of the legal system, such as the guardian ad litem, and how information is being documented, which can affect how it's shared down the road. It is important to share this information up front with every client, but once litigation begins, it is important to maintain that consistent transparency with our clients so that they are aware of what is being shared and how at all times. And once again, the prior slide and the slide and all slides moving forward with the ethical considerations reference the specific sections of the AA-MFT Code of Ethics that have to do with each of these topics, so you can review them on your own time for further clarification. So this leads us to discussion on the therapeutic alliance. Our first and foremost ethical consideration is ensuring that our work with clients does not bring harm to them. Our work is to promote the well-being of our clients and ensuring that the therapeutic alliance is protected, even through litigation concerns, will be priority. A key way of doing this is through transparency, as we mentioned before, and helping them understand our role in the divorce and promoting the next key point, which is client autonomy, by allowing them to use the information we are sharing with them to determine what the next steps will be regarding our involvement in their divorce. We have to remember that we are experts in our field, but they are experts in their own life. We can provide information about how our roles as MFTs that might affect outcomes and allow them to make decisions on how they want us to be involved. Lastly, all of Standard 7 provides guidelines specifically for professional evaluations and can be referenced for specific guidelines regarding testimony and legal proceedings. Section 7.7 in particular indicates that if a therapist has been working with a minor who becomes part of a custody battle, that therapist should avoid conducting the evaluation for custody for that family and resort only to providing information to the non-biased party conducting the evaluation. We mentioned that before on one of our prior slides, but it is a very important aspect to reinforce, as we often will be working with families and have them pursue these different legal processes. So we need to be aware of our limits and how we can be involved in those processes. All right, subpoenas. Understanding the origin of a subpoena is important because it affects the options for responding. Court-ordered subpoenas are different from subpoenas sent by a private attorney, as those sent by attorneys provide a little more leeway in how the therapist can respond. While it's important to consult legal aid for responding to any subpoena, there are certain additional considerations that come with one sent by an attorney. When a client's attorney sends a subpoena, it may appear as if the client is giving consent for that information to be released. However, it is important that even if a client's privately hired attorney requests the information, that the client still provides signed consent directly to the therapist that the information requested to be shared is approved to be released. It is also important to be aware of state laws and what your state's requirements for responding to out-of-state subpoenas are. Not all states have the same regulations, and therefore not all states are compatible when it comes to eliciting professional testimony. This is another good area to understand independently and also to seek legal consultation on. It is vital, however, that therapists understand that a response is required. Whether or not the therapist is going to comply with the specific request in this subpoena, a written response provided to everyone involved, including the court, is required by the due date listed on the subpoena. Once again, seeking legal consultation and providing a response is always recommended. The client's attorney can take action to quash the information being requested in the subpoena, but a response from the therapist is still required. Client partnership needs to be at the center of any subpoena response. It is always our duty to avoid harming our client, so being transparent with our client about what is requested, what is being shared, and how feedback on this may affect the client moving forward are all conversations that must take place ongoing throughout the entire litigation process. The therapeutic alliance is always priority. Lastly, we all know that HIPAA is our guide when it comes to protecting privacy. However, HIPAA does not always have the final say. While HIPAA allows information to be released via subpoena order, not all states are on the same page. Therapists are then left with conflicting information, but the rule of thumb is to follow the law that offers the most protection. If the state that the therapist is practicing in offers more protection for privacy than HIPAA, the therapist should abide by the state regulations. After all, our overarching goal as professionals in the helping field is to promote that well-being of our client in any way possible. Thank you for joining me for today's presentation about the role of MFTs in divorce-related legal issues. Please look over the resources referenced throughout these slides and don't hesitate to reach out with any questions or to further this conversation.